All right. All right. So go ahead, Miss Leak, and tell me what is going on. It is my understanding that there was a damages amount of $4,575 from the magistrate court.
Yes, ma'am. So I was living in the property for 6 years. The previous owners, the wife had passed away, so the husband sold the property. However, Ms. Mora allowed me to still stay there. She gave me a lease for 6 months and the price of $70.75. And if I needed more time, I can stay there. So came January, I still needed more time. She let me stay there for another 6 months without a lease, but she told me that she would charge me $1,100, which was fine. Came July of 2023, Ms. Mora told me that she was going to, I guess, reconstruct the property, and that I had 60 days to move out. Let me back it up. Prior to me moving in there in 2017, I moved in the property as is, meaning that the carpet was old, I got it clean, no new painting, the appliances was very outdated, countertop very outdated. The owners at the time let me do the countertops over. I did carpet cleaning, I wiped the walls down, fit enough for me and my daughter to live in. Okay, so let's go back to July of 2023. When I was told that I had 60 days to move out, I went and go seek housing for me and my child. And I wanted to hurry up and do it before my child went back to college in August because I knew I was going to need the help. So I found something. The agency told me that I would have to pay, the deposit to move in. I did that, and I went straight ahead and moved out. I had a week to move out because my daughter was going back to school. And like I said, I was going to need the help. Ms. Mora still wanted me to pay the rent there. So I told her, hey, I had the money to move out. I didn't have the money to pay you another month of rent.
Okay.
You already gave me.
Hold on. Okay. Slow down for me because I need to understand. So Ms. Mora gives you a 60-day notice to leave.
Yes, ma'am.
Okay. And how long after that did you move out?
I found something in the beginning of August, so it was like maybe 30 days. Within 30 days, I found a place.
So what was she charging you for?
She wanted to charge me another $1,100 for another 30 days. But like I said, I didn't have.
Ms. Mora, you asked her to leave. You gave her a 60-day notice, which is required when the person doesn't have a lease, but they're working under a previous lease or the previous lease terms. The landlord is required to give a 60-day notice, and within that 60 days, if the person leaves, why would you then charge her for an additional month?
So there's gaps in her story. So do you want me to say my side of the story? Or do you want to finish until she says it? Because that's not exactly how it all went down.
Okay, let me hear the rest of Ms. Leak's story. Okay, Ms. Leak. So August 2023, you find the new place, and you said Ms. Mora wanted you to pay another month.
She wanted me to pay from August to September.
Okay.
Another month of rent. So the money that I had to move was to move because I had to move because I didn't want to be homeless within the next day, paying her and then trying to pay a security deposit for a new place for me to stay.
Okay.
So as I was moving, I'm trying to hurry up and do everything. And she had reached out to me like, hey, you have to pay the rent. And I'm like, oh, hey, by the way, I found a place. Because prior to that, she had signed.
Hey, let me ask you this. Had you paid the rent for July?
Yes, ma'am. I paid the rent for July.
Had you paid the rent for August?
I didn't pay no rent for August.
But you were still in the place in August?
Well, I had moved out. I had moved out August the 5th.
August 5th?
Yes.
Okay.
Yes. So she had signed as a reference for me for my new place. So she already knew that it was getting close to the work because she had signed it for me. So August the 5th, she reached out to me and she said, hey, you haven't paid the rent. And I was like, oh, I got the place. I'm just talking to her because she was so nice to me the whole time I was there. I'm like, I got the place, like excited, because I know I don't have to wait and figure out if I'm going to be homeless or what the case
I got that. But did you move on August 5th or you moved after?
Yes, I did. I moved. Yes, I
All
moved
your
out.
stuff was out of the place.
I got everything out there the same exact day. I think it was the 6th. I'm sorry. The 5th and the 6th. Yes, ma'am.
Okay.
So
All right.
rent is normally due on the 5th of the month.
Okay.
And I moved everything and she was saying, well, if you don't give me the money by this time, I'm gonna have to take you to court. I'm like, well, I had to move. Like, I didn't want to be homeless. I wrote her a letter and everything like, hey, this is what's happening. On this day of August 2023, me and my daughter, we both signed the paper and said that we was moving out the place. I found the place. I knew you knew it was coming because you gave me 60 days and also you found it as a reference for me to move into, so I can go to the next place. And it got approved. And then after that, I had got papers from the court saying I had to come to court. And it wasn't even for the $1,100. It's like she wanted me to do remodeling on the property. And I was so confused about that because I didn't do any damages to the property. When I moved out, I took everything out. I cleaned everything. Anything that was left in there was stuff that was from the prior landlord that he had there when I moved there. And I didn't touch it because it wasn't mine. But like I said, appliances outdated. The townhouse was outdated. I just made it fit for me to live in.
All right. So what else happened?
I can't hear you. Went out.
I'm sorry. What else happened? So you
And then
came to court.
I got the papers for me to come to court.
Okay. And what was she claiming were damages that you had to pay for?
She had it on there for like the appliances. I can't recall everything they had. The court said they was looking everything over, but basically it was like up to like $7,000 worth of damages for the house, and it wasn't no damages. No.
Okay, were there holes in the wall?
No, ma'am.
Okay, did she allege that you had put holes in the floor?
It wasn't no holes in the floor. I don't know where her
damages copper missing?
Nothing missing.
Light fixtures?
Nothing. Everything was still as is. I moved in 2017.
All right, and how much did the court grant in this case? 4,000 what now?
No, the whole thing was like 7,000 and something. I don't have the whole dollar amount, but I know it was over 7,000 versus me paying $1,100 for a rent for 1 month.
All right. Okay.
And then she also had security deposit that the prior landlord gave to her from me after he gave her a reference to ask if I can stay into the property.
Let me ask you this. So with the security deposit, did she give you the opportunity to do a walkthrough with her so she could do a list of all the things that were damaged?
Were you saying a walkthrough the last day? Or
no.
Walkthrough when you bought the property?
When you told her I'm moving, did she send you notice that you could do a walkthrough of the property with her?
No, she just sent me a message saying that.
Did you ever receive a list of damages from her prior to coming to court?
No, ma'am.
Okay. So then she used the security deposit that you had as damages in this case?
I think when the court summed it up, they had put the security deposit in there and minus it from what she was asking for.
Okay, and how much was the security deposit?
It was $775.
All right. So let me ask you this. So did she ever send you a notice to either your address at that place and it got forwarded to you, or to the new address that you had the opportunity to walk through the property with her to determine if there was any damages?
No, ma'am.
Okay. And did you receive anything from her after you moved out that said, these are the damages I walked through and saw, so this is how much of your security deposit I'm going to keep?
No, ma'am.
Okay. All right. Is there anything else you want me to know?
No, ma'am. That'll be all.
All right, Ms. Mora.
So I just, I'm kind of flabbergasted by what was stated. Nonetheless, I don't see that a judge would have granted me the amount that I would
be in magistrate court. A lot of judges don't know about the security deposit. And if they don't look, they might not realize it. We're not infallible. But under section 44-7-33, there's an actual procedure by which you have to go through to document damages, to keep her security deposit, to determine any other damages.
I did everything as the Georgia law stated. So on July 7, 2023, she was provided a 60-day notice. It was emailed to her on that date. It was certified mailed to her. All these docs are actually in the file that was submitted on the magistrate court. And also the hard copy was also put in her mailbox, which also I have pictures of.
Okay.
So this was all provided to her, and as you can see on the file, I have the hard copies here as well. So this is a 60-day notice that was given. This is the courtesy email notice that was given to her, and this is the certified priority mail express that was delivered to her door. And also I went and drove over there, and I also placed it in her door.
Okay, so she's not arguing that you didn't give her the 60-day notice. I think she's her argument is about the damages.
Right. And so furthermore, on the email, I also stated a move-out inspection is optional, must be requested in writing, and must be completed 7 days prior to September 5th of 2023. The $750 security deposit per the rental agreement is to be returned within 30 days rental agreement has terminated. Less any damages, security deposit shall not be credited towards rent unless the landlord gives written consent. 60-day notice to vacate is attached. I will stop by the property this afternoon before 1:30 and hand deliver you the notice. If you are not at the property, I will make sure to post it on the door. Lastly, the 60-day notice will also be mailed first class. So this was provided to her via email. To the
and what was the date at which she had to do the move-out inspection? Give me that part again.
September 5th.
Okay.
By 2023. I gave her the 60-day notice on 7/7, right?
Okay.
It allowed us ample time to do it September 5th.
Okay.
So she never responded to the move-out inspection. I then get a text message on August 6th stating that she's moving out of the property. I told her she did the court claim, which was, I think it was close to $7,000, right here goes, $7,410. That's what all of my receipts added up, and I also asked for the court costs to be reimbursed.
Okay, and you kept the $775 security deposit.
Correct.
Okay. All right. What were the most expensive items that you had to replace?
The most expensive items, let's see, hold on, I have my receipt. The bathrooms.
Mm-hmm. What did you have to replace in the bathroom?
The carpet, I understand that's prorated because she was in there. I also replaced the carpet.
Okay, no, carpet is turnkey, ma'am. I'm not giving you anything for carpet.
Right, that's fine. So basically it was the kitchen area.
What did you do in the kitchen? What did you do in the kitchen?
Do all of the cabinets, and I have pictures of all that.
What do you mean do all of the cabinets? What do you mean do all?
The cabinets worked. All of the doors and the inside of the cabinets that were warped with the stuff that she left behind there, and also the bathrooms. The bathrooms were the same thing. The vanity, I had to replace them. I had to replace the toilets. I had to replace the kitchen countertop. I had to replace all, I don't know if this is included on the turnkey. I had to replace all the appliances. I had to replace the refrigerator, everything you can think of. This is the stove top where she left. It was literally burning a hole onto the dripping pan on the stove.
So you can buy dripping pans separately. Those are about $4 or $5. So why did you have to replace the entire stove top?
Because the stove top, let me show you what it looked like. This is why I had to replace the dishwasher because it was not working.
Okay. Ma'am, Ms. Leaks, how long did you live in this property?
I lived there since 2017.
And Ms. Mora, how long did you own the property?
I purchased the property on 2022.
And did you put any new appliances or anything into the her living unit when you purchased the property?
I did not, because there was nothing to
No,
be
no,
replaced.
no. Listen to me. Listen to me. Did you paint when you moved in when you purchased the property?
No, because there were
Did you
no
replace
damages.
Did you replace the flooring when you purchased the property?
No, I did not, because there were no visible damage
Okay.
at that time.
So at this time, you've already received the $775 for the security deposit. Ms. Leaks owes you $350 for the pet damages. And the rest of that is turnkey, because you would have had to do all, she's been living in that place for 6 years. When you bought it, it had all of those old appliances, it had the old fixtures, it had, no, Miss Mora, I don't care if there was no damage when you bought it. It is a place where a renter has lived for 6 years. There's gonna be holes in the windows, screens. There's gonna, ma'am, when I tell you I am experienced in rental property, not just from being a magistrate, you're trying to put your turnkey cost on the back of the tenant. Yes,
Absolutely not.
And you probably did it before.
Absolutely not.
Yes, ma'am.
Absolutely not.
Yes, ma'am. And she's not required to pay the additional month's rent. You gave her 60 days to move out before an action could take place. She moved before the 60 days, so you're not entitled to the month's rent. She moved within the time period that you asked her to move.
I'm not disputing that, but that's already been established. I'm here because at the time of the move-in, the condition of the unit was not as she left it when she left. And regardless of normal wear and tear, this was beyond normal wear and tear.
Okay. So you said the bathrooms, the cabinets, you had to replace all of those. What else was the most expensive thing you had to do?
The most expensive things were the bathroom, the kitchen, I had to literally do everything. So I don't know where that falls in your criteria.
Miss Mara, I'm just not impressed by that, because you bought an old property. The person was already living there. There was already going to be issues because you had a tenant in the place. Every time you bring in a new tenant, there's going to be some turnkey, especially when they've been living in a house that long. You bought a property and you didn't replace all of that stuff when you bought it. So what you're dealing with is a tenant who's already dealing with old appliances, and all of that. That's all part of being a landlord, ma'am.
Just because things are old does not justify her messing them up to where now they're inoperable. When we did the walkthrough, those items were not like that. Had those items
did the walkthrough
like
in 2022? It's 2025. Had you been in the property since then, Ms. Moore? Had you been in the property since then?
Say what?
Had you been in the property since 2022?
No, because she never reported it.
Did you do periodic inspections?
No, because she never reported anything.
It doesn't matter. You have the right as the landlord to do periodic inspections. And if there's issues, then you can address them at that time. But if you went from 2022 to 2023, 2024, you never even went back to look to see if there was damages. And you're saying that it should have been pristine from the time she first started living there, or from the time you bought it until the time she moved out.
I'm not saying that it should have. I just want what's fair.
And I'm gonna give you what's fair. What is fair, I think, is about $1,500 to $2,000, because other than that, all of that stuff is stuff you had to do anyway. to bring in a new tenant. That's the cost of doing business as a landlord. And I also know you're going to take it off on your taxes because that's how you run a business. So what you're looking at is a double recovery when these aren't things that you get from a tenant, especially when you're not doing periodic inspections and you can't follow the decline of the property. Now, if you told me at some point you were in there looking at it, but when we're talking about blinds and window screens, that is the cost of doing business as a landlord. And if you haven't ever had to replace stuff like that before, you're not doing it right.
I don't understand. So it's okay for an individual to rent someone's property and purposely cut blinds. That's normal wear and tear. You're telling me that it's okay for an individual to have your dog bite the bottom of someone's blinds. You're telling me it's okay for someone to remove the smoke detector and then it probably can cause a fire due to you not having the installed smoke detector. You're telling me that it's okay for her to have rust at the top of the stove that she supposedly had cooked in. You're telling me that it's okay for her to have rust at the refrigerator?
Ma'am, those refrigerators were old. You don't even know when they were purchased. So rust on a refrigerator, or rust on a stove, you don't even know when they were purchased. So you didn't purchase them.
I seen it in 2022 when I did a walkthrough. It was not like that. That's what I'm trying to tell you.
I don't care. That was 2022. This is 2024 you're talking about.
So you're okay for her from 2022
Ms.
to the
Moore,
time she left.
I'm not going to argue with this. Tenants do all kinds of crazy stuff. I will grant she shouldn't have had a pet. You're charging her the $350 for the pet. I will grant you've kept her to her $775, even though you didn't send her, you didn't update your inspection requirements once she moved out of the property. You set them thinking that she was required to stay in the property, which that makes no sense to me. You give her a 60-day notice and you think on the 60th day she's going to move out on that day into a new place, instead of you're giving her the notice for her to within the 60 days move. Then you didn't update your inspection procedures, an inspection notice. You didn't send a damages report to the last known address. In some cases, she might even be entitled to triple her security deposit because you didn't do it right. Even if you go through the process of doing a damages walkthrough after the person has left, if you're going to keep their security deposit, according to the law, you're supposed to then send the damages report to their last known address. You say you didn't send it, but you're asking me what's fair about a property where you bought it with old appliances in it, you didn't inspect periodically, and you want the court to give you the cost of turnkey. Not going to do that. At this point, I will grant you the $775 and the $350 for the dog. I will grant you the $775 and the $350 for the dog. The rest is the cost of doing business.
So what is the total? You said $775 and the $350?
And you've already gotten the $775 because that was her deposit, and the $350 she'll pay that.
Okay, so can I have that paid? Can you give her a date to have that money rendered to me?
I don't generally do that because it is your job to collect it.
I'll garnish her wages, not a problem.
Once I give a judgment, it is upon the person who prevails to collect the judgment. But Ms. Mora, sit down with an attorney who's knowledgeable because everybody who thinks they know the law, well, I'm doing it by the law, and you're telling me it's month to month when you clearly have a lease that you've negotiated. So sit down with somebody.
Well, this is a lesson learned here in Georgia because it doesn't work like that in California.
No, ma'am. But that's the problem. Everybody comes to Georgia thinking it works like it does up north, where it's no,
right.
It does not.
Well noted.
You can't just come here thinking you know the law. No, ma'am. It doesn't work the same in any other state. Every state has nuances.
Absolutely. I never said I knew the law. I'm not an attorney.
You did. You said I did it by the law. And you said that 3 times to me. When I first asked you what was going on, you talked about I did it by the law. And then you immediately told me You had a month to month and a lease.
Are you going to be able to set a date where she needs to render the money, or do I need to garnish her
No,
wages?
ma'am. You need to do whatever you need to do to collect it. I don't collect. I just give the judgment. So
Sounds like a
$350
plan.
For the judgment.
Sounds
All
like
right.
a plan. Thank you.
You're
Thank
welcome. Take care, ma'am. All
Thank
right,
you.
Miss
Thank
Lee,
you.
you'll pay the $350.
Okay, ma'am. Thank you so
All
much.
right. You're welcome.
All right. Bye-bye.
Okay. All right. So the next case, did we ever get?
At this point, the judge delivers one of the most important lessons of the entire hearing. She explains that landlords have the right to perform periodic inspections of their rental properties. If damage occurs, they're supposed to document it early and address it before it gets worse. But the landlord admits she never performed regular inspections after buying the property. That means there's no clear record showing when any of the alleged damage actually occurred. Without that evidence, blaming the tenant becomes almost impossible. The judge bluntly tells the landlord that trying to charge the tenant for renovation costs after years of occupancy simply doesn't work. Many of the repairs she's claiming, floors, cabinets, appliances, are the kind of upgrades landlords normally make between tenants anyway. Finally, the judge delivers the ruling, and it's not what the landlord expected. The court explains that most of the claimed repairs fall under normal business expenses for rental properties. However, there is one issue the judge does recognize. The tenant had a pet in the unit despite a lease clause prohibiting animals. Because of that violation, the judge orders the tenant to pay the $350 pet fee. The landlord is also allowed to keep the $775 security deposit, which she had already collected. But the rest of the $7,000 damage claim is rejected. The judge makes it crystal clear that landlords cannot shift renovation costs onto tenants without proper documentation and legal procedures. With that, the case closes, and what began as a $7,000 dispute ends with the tenant owing only $350.